Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II.
Welcome to the Texas Commercial Litigation Podcast with J. Robert Arnett II, principal at Carter Arnett in Dallas. Bob has more than 35 years of experience handling complex business, intellectual property, and real estate disputes in Texas and federal courts nationwide. I'm Lisa Mosby, your host, and today we are looking at the strategic differences between litigating in federal court and Texas state court in commercial cases. Bob, thank you so much for joining me today.
Well, thank you. It's good to be here.
Yeah, Bob, when a new commercial lawsuit is filed, how does the choice between federal and Texas state court shape the trajectory of the case from the onset?
Well, it depends on what kind of case it is, but, sometimes you would much rather be in federal court and sometimes you would rather be in state court. State court, if you've got the sort of the home field advantage, state court is probably a better place to be. If you don't, but you're compelled to file in a forum or a state that's away from your base of operations. It's not your home court. Then you very well may want to be in federal court. But there's also considerations about the judges. The federal judges are appointed by the president, confirmed by the Senate. Tend to be I would say, higher quality judges than the state court judges, although, we do have some very fine state court judges, but state court judges are by and large elected by the people. And, sometimes, most voters don't know hardly anything at all about the candidates when they vote for them. So we've got, I would say the quality spread in the state court is a lot broader than it is in federal court. So that's one thing to be cognizant of. I think I mentioned the type of case. If it's particularly a complex commercial case, you may well be better off in federal court, where judges tend to see those kind of cases more than state court. Where in some state courts, the judges deal with every kind of case: family law cases, criminal cases, as well as civil cases. In federal court, that's not the federal judges do have both criminal and civil, but, it's, I would say, extremely rare to see, any sort of family court issue in federal court. But federal courts they're courts of limited jurisdiction. So, you would either have to have what's called diversity of citizenship jurisdiction, which is, where the lawsuit is between citizens of different states. And the amount in controversy is more than $75,000, or typically federal question jurisdiction means you've got a federal cause of action. You can sue under a federal statute, to get into federal court. In terms of if you're a plaintiff and you want to stay in state court, you want to be in state court, one of the tactical considerations is who all do you sue? Because in order to remove on the basis of diversity of citizenship, you can't have any defendants who are citizens of the forum state. So in other words, if I'm suing somebody in Texas, and I'm a Texas resident, or my client's a Texas resident, but the main defendant is, not from Texas, they're in a different state, you would look at, is there somebody else that we can join as a defendant who would be a Texas resident? And then that way we would be able to stay in state court, with the caveat that there is something called fraudulent joinder. And so you may have to fight about that. So, those are some of the considerations.
And that's quite a few, to be honest with you. I'm curious, Bob, what procedural differences between the two systems tend to have the greatest practical impact on business litigants?
I would say there's not really that many procedural differences. Some of the procedural differences are in Texas. If you want to challenge the venue, in other words, say you're a defendant and you claim that you got sued in the wrong county, you want to be in a different county, that's something that has to be done right at the very outset. before you file other things or you waive it. Same thing with personal jurisdiction. You have to raise that right away, or it's waived. In federal court, it's a different procedure, but those issues still get litigated there. It's not there are not the you call them traps for the unwary. If you say you're unfamiliar with Texas procedure and you go ahead and file an answer and you try and include in that answer a challenge to the jurisdiction of the court, the personal jurisdiction of the court. Well, you've waived it. Sorry, you're here. You're stuck. In federal court, you can file an answer and you can include defenses like lack of personal jurisdiction, and then bring a motion to litigate that issue and hopefully get the case moved. So I guess another procedural issue or difference is in Texas, if the court doesn't have personal jurisdiction over you, typically, or venues incorrect, let's start with personal jurisdiction. The court just has to dismiss the case, and you're kind of stuck. If it's in federal court and there's a venue fight or a jurisdictional fight, it's possible to get the case transferred to another federal district. So those are some of the procedural distinctions. I think in some of there are some motions for summary judgment in both state and federal court. I think that the difference in terms of the tactics is, as a general proposition, federal court judges are probably more amenable to granting summary judgments than state court judges are. Same way with motions to dismiss, and there are differences. The Texas motion to dismiss is a more limited device than the motion to dismiss under federal practice.
So, a follow up to that question, Bob, is how do discovery rules and scheduling practices in federal court compare with those typically seen in Texas state courts?
Well, again, they're similar, and they've become more similar over time, mostly due to changes in the Texas Rules of Civil Procedure. But discovery in federal court, you can't undertake discovery unless you get leave of court. Say there's an injunction and you need discovery right away. You have to ask the judge to let you do early discovery and expedited discovery. But typically in federal court, you have to have what's called a Rule 26F conference, where the lawyers on each side get together and they talk about the scheduling of the case, and they talk about discovery, and then they file a report with the federal judge, and then the federal judge kicks out a scheduling order, and within a certain amount of time, you have to serve your initial disclosures, which is, a collection of sort of basic information about, discovery that is going to be needed in the case, names of people with knowledge of relevant facts, relevant documents, things of that nature. In Texas also has initial disclosures, but you don't have to wait for a conference. You're obligated to serve those 30 days after the answer is filed. And but again, you can't start other forms of discovery until the initial disclosures have actually been served out. So there are some differences, but there's also a lot of similarities.
Sure. And in terms of motion practice, how do judges in federal court approach dispositive motions differently than their counterparts in, say, a state court?
Well, as I said before, I think as a general matter, federal judges are probably a little more amenable to granting dispositive motions, either motions to dismiss or motions for summary judgment, than most state court judges. There are obviously exceptions, but that's kind of a general proposition. Most federal judges do not hold hearings. In other words, they don't entertain oral argument on dispositive motions. There's the motions are briefed, and then the judge decides it when he or she gets around to deciding it. In state court, typically for dispositive motions, there is a hearing set, and the timetable for briefing is based on when the hearing is. Responses are due 7 days before the hearing for both motions to dismiss and motions for summary judgment. Um, and then you have the hearing, and then the judge decides it. Motions to dismiss also have time limits on how quickly the judge has to decide it. And then the summary judgment practice in Texas just changed also, because there's now a requirement, more requirements on judges in terms of disposing of summary judgments, and in terms of timing. They have a limited amount of time to decide them after they're filed and heard. So that has impacted, for example, in Dallas County, it used to be you could have a summary judgment motion heard up to 30 days before trial. Now they've just entered some local amendments to the local rules, general orders in Dallas County, that you have to get your motion for summary judgment on file. I believe it's 90 days before the initial trial date. So that compresses the time that litigants have to get their summary judgment motions on file.
And we know that jury composition and jury dynamics can vary depending on the venue, but how does that factor into strategic decision making in complex business disputes?
Well, so the difference is, say, for example, Dallas County, if you're in state court, your jury is going to be drawn from people that reside in Dallas County. In federal court, if you're in the Dallas division of the Northern District of Texas, that embraces, six different counties. So you've got Dallas, you've got Navarro, you've got Rockball, you've got Hunt. I think you've got Kaufman. So you could be drawing people. People on your jury pool could be from farther afield, which has a couple of things, because the outlying counties tend to have different demographics than, say, the big city counties. And, that's also true for Harris County. The Houston division of the Southern District of Texas, I forget how many counties it embraces, but it's more than just Harris. So you've got Harris, you've got Fort Bend, you don't have Montgomery. Montgomery is in a different division, but you've got some fairly populous counties surrounding Houston with different dynamics or different demographics and different politics. Some of those counties surrounding Houston are pretty Republican, but Harris itself is very Democratic. So that matters.
And then removal to federal courts is often an early battleground. What considerations influence whether a party seeks to remove or remands a commercial case?
So, again, I would say that, obviously, if the case is in state court, the plaintiff wants to be in state court. So the defendant, wants to remove, and then, you have to look at considerations of whether you can remove. Typically, it would be diversity of citizenship jurisdiction, which requires that you analyze the citizenship of the parties. I mean, for people, that's pretty straightforward. But for business entities, that is a more complicated question. For example, a corporation is a citizen both of the state where it's incorporated and the state where it has its principal place of business, which is considered to be, call it the nerve center of the entity. So, there are lots of companies that are incorporated in Delaware, because Delaware has pretty well defined and understood business law, and but then they could have their headquarters anywhere else, so they might be a citizen in two different states. Then the real wild card is if you have a limited liability company that is a party. A limited liability company has the citizenship of every one of its members. So you need to, um, if you can, find out where those, where the members of the LLC are that, uh, make up the membership of the LLC. And if a member is also an LLC, then you got to do the same analysis with respect to that entity. So it can be, fairly daunting. And, some federal judges have a more lenient approach to letting you uh, plead diversity of citizenship on information and belief, or others have a much more strict view of that. A lot of federal judges don't particularly like to see cases removed to their court. Those they kind of view it as those cases, were originally filed in state court, and they really belong in state court. We used to have a judge in the Dallas division of the Northern District of Texas who would just remand cases on his own until the Fifth Circuit told him he couldn't do that anymore. Um, so, and then the deciding whether to remand. Most removals, assuming that you've got diversity of citizenship, or you've got a federal question, and you have the right amount, at least the right amount of money in dispute, uh, and you follow the procedures. In other words, you filed your notice of removal no more than 30 days after either you got served with a complaint or that you first found out about the complaint. Then you can generally stay there. If there's a fraudulent joinder question, like I mentioned earlier, if somebody is, you know, brought in a Texas individual as a defendant who really, it's questionable whether they really belong in the case or not, you're going to have a motion to remand and an argument about whether that person was fraudulently joined, meaning they really don't have any business being sued in this case. They're just here to defeat diversity. So those are considerations. A lot of times, not a lot of times. Sometimes, plaintiffs are perfectly fine with the case being removed to federal court. Is there's also a wrinkle because there's also the ability to remove a case that's related to a bankruptcy, and so, but there's more opportunities to get those cases remanded if you want to actually be back in state court. There's mandatory abstention, there's permissive abstention, and there's something called equitable remand. So the bankruptcy judge would have more discretion to send a case back to state court than typically a district judge where the case has been removed based on diversity.
So, Bob, for corporate counsel evaluating form strategy at the onset of a dispute, what internal considerations tend to matter the most before making the decision? And that's where we'll leave it for today.
Okay. Well, I would say, so you're talking about the plaintiff's side because you're talking about the decision about where to file. It depends on the nature of the dispute. And if you, and also if you think that state court would give you a good home field advantage, you'd want to be there. The other wrinkle in Texas is we now have what are called the Texas business courts, where you have appointed judges who are very well qualified and well respected and understand commercial litigation very well. So, that's a consideration too. Do you want to try and get into the Texas business courts? So, nature of the dispute, how favorable is the forum? Is the state court forum to you? Or is it really, a case that you think you'd be better off with a decision maker who's a federal district judge?
Perfect. We'll wrap it up right there. Thank you so much. We appreciate your insights today and trying to clear up some of these complicated issues. And I know so much of this it depends on the case. So I appreciate you diving deeper into that. And folks, that's it for today's episode of the Texas Commercial Litigation Podcast with J. Robert Arnett II of Carter Arnett. To learn more about Bob and his firm's work in business and intellectual property litigation, visit carterarnett.com. Thank you so much for listening today. And remember to like, subscribe to the show, and leave a review if you found this episode helpful. We'll see you next time.
Okay. Thanks, Lisa.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.